So can I ask it this way? I guess I'm trying to understand why it's atextual, in your view, to focus on this idea of use of a mark as a source identifier. Because it seems to me that what you're describing as the problem is courts grappling with the degree of expressiveness of various items in terms of determining whether or not this Art Rogers exception should apply. But I wonder whether the cleaner, more sort of consistent with the statute way of looking at it is to ask, is the artist using this mark as a source identifier, as the threshold? And if they aren't, then I guess the Lanham Act doesn't apply because, as you've said, the Lanham Act worries about confusion that arises from use of a mark as a source identifier. So if they're not doing that, then there's no trademark problem. But if they are doing that, if it's being used as a source identifier, then I suppose we get into all of the questions under the Lanham Act test as to whether or not there's trademark infringement. What's wrong with that?
Well, unfortunately, a lot. And with respect, that literally you're taking language in the text of parity and in the text of 1115b4, which you had a Supreme Court case on, KP permanent makeup, saying other designation of a source are actually exceptions under two statutory provisions that don't appear in infringement. So I'm fine with you making up stuff.
No, but I'm not making it up. I mean, you said here this morning, and I wrote it down, that the whole confusion issue. Do you agree that confusion is the heart of the Lanham Act?
Confusion has nothing to do with designation of source. So no, you're sorry, but in trademark law, you can have a very confusing use of a trademark.
But I'm sorry, Ms. Blatt, you said a few minutes ago that it's misleading as to origin of source or sponsorship, that's the confusion that we care about. That what the Lanham Act is trying to do is say, are consumers confused as to the origin, source, or sponsorship of this product? And I agree with you, but I'm wondering then, why isn't that the threshold question?
Just let me give you an example. The famous film pre-Rogers case, the Dallas Cowboy cheerleaders, involving 12 minutes of graphic sex involving a trademark, was not a source identifier. It was just a very confusing use of a trademark. Source, let me just explain what a source identification means. It means a consistent and persistent origin of source, even if the source is unknown. So like iPhone, even though there's not a company called iPhone that makes the phone, it's Apple, iPhone is a trademark. But you can infringe iPhone's marks or any mark without indicating it's a source. You can put it on a T-shirt, you can put it in a movie, you can sell lots of products, it's just not being used as a trademark. And the statutory definition of infringement has nothing to do with use as a source. It's any use of a mark likely to cause confusion. And I know that I'm right about this because its designation of a source is an explicit carve-out under infringement.
All right, likely to cause a confusion in what way? So fine, you put the Apple mark not on something that looks like an iPhone so that people are confused about the source of that product. You put it on a T-shirt. So likely to, how is that a trademark infringement in the sense of origin of source?
Sure, if you just put a T-shirt that says Apple sucks, that is a diluting, it's a use of the trademark. It doesn't indicate a source. It's just a statement. If you have put your favorite cartoon character in a movie, that's not a designation of source unless I'll put it this way, like a title is not a designation of source. Gone with the Wind is not a designation of source. It has to be, Harry Potter might be, but just standard trademark law, and you can look at any case or any McCarthy, and it'll tell you that you can violate the trademark law even though you're not engaged in trademark use.